Salam Kroto and very good afternoon. We are going to complete our last lecture on the last topic. This is going to be part of the topics inside the BENR 4322 Jurutera Masyarakat. We're going to discuss about the contract law. Okay. Contract law is basically a foundation of all commercial activities. By right, every one of us is actually already have this contract almost out of the life lah. So, for example, very simple example, when you want to purchase or you want to buy your food, so actually you are entering a contract and you're going to complete because all the elements of the contract is there because you're going to have the consideration and all the stuff to pay, and then this is actually a contract. Okay, all right. Let's move on. In legal definitions, so we are going to refer the Contract Acts basically based on the laws of Malaysia over here. So it's actually the Contract Acts 1950, where the related of the Contract Acts talking about when a person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other such act or abstinence, he is said to make a proposal. So you must have a proposal. So this is words for the what you call that? Yeah, lawyers' words, right? So this is not really our layman words that we're going to use most of the time. So the second one is about the all agreements are contracts. Okay, all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful considerations and with a lawful object, and are not hereby expressly declared to be void. So this is basically very sophisticated words because we are not really use it most of the time. So we actually want to learn more by using our own very simple English. All right. Okay, in definition, contract law is a fundamental aspect of conducting business, providing a legal framework for agreements between parties. Okay, some contracts are written, but they are also implied formed to the parties' conduct and oral contracts. A contract is an agreement between parties creating mutual obligations that and are enforceable by law. So you have to know that most of the contract that we have, for example, we are going to sign, right? Means it's actually going to create a legal intentions. Then it must be what you call it, follow up and it enforceable by law. So that will be a contract. Okay. Okay, the concept, the freedom of contract. So any one of us is free to enter any contract without any pressure, and we are free to decide our terms and conditions. This is on the contract itself. So the second principle of the contract is it must have a certain offer, certainty. The offer must be firm, and there must be a definite intention to adhere to the offer. So this is the general principles of the contract. Right? So we have three types of contracts basically. So you just know that we have the unilateral contract, you have the bilateral contract, and the last one you have the collateral contract. So unilateral is basically only one directions, and bilateral means both offer and the second person A and B is going to make a agreement based on what they're going to promise and promise both of the parties. All right. So for example here for unilateral, for person A, right? So the thing is promised to pay, and this is just doing the wash the car. So you see that the bilateral example here, both promise to do that one. So it's actually there's a promise to pay and there's a promise to wash your car. So that is actually bilateral. So this one is not bilateral. This is only unilateral because only one person to promise and the other one just execute the thing. All right. So that is actually between the difference between unilateral and bilateral contract. All right, the third one, they call it collateral. This is a quite just a separate and independent contract which is exists beside the main contract. So if you have a contract, main contract over here, and you have another contract which is a separate and still related to the contract, main contract, so that is actually a collateral contract. All right. So for instance, right, A landlord promises the tenant to fix the lightings while there is a lease agreement. Okay, there is a collateral contract to fix the lighting, even though it is not in the lease agreement. If, okay, if, let's say for example, this is the contract that we have, the main contract. So even though there's no saying over there. So this is just the example of the contract for the ballot for the collateral. Okay, okay, let's move on. Now you have to memorize or remember most of the elements of the contract. Not most, you have to remember all of that. So basically we have up to 7 elements of contract. So if one of the elements is not inside the contract, so the contract is void basically. So it's not actually a contract and that cannot be enforceable by law. All right. So we have to go through all these elements of contract and understand it. Right? Okay, so let's go for the first one. There must be an offer. The second one, there must be an acceptance. Of course, you have offer, you must have acceptance. And then you have the intention to do it. Then you have the considerations. What are the considerations in terms of the contracts? Okay. Then you have the capacity. Okay. Then you have the free consent. And the last one, it must have a certainty in the contract. Okay, let's go through one by one. The first one, offer. So one party is going to make an offer. So okay, an agreement between two or more parties is constituted by a proposal. An offer or proposal is necessary is for the formations of an agreement. Okay, when a person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the essence of that other to the act of abstinence, he is said to make a proposal. So it's very simple. The first party must make an offer. Okay, just look at this example here. So this lady say that I want to sell my car for RM25,000. This is an offer. All right. So of course, if the contract is going to be valid, there must be an acceptance. That is a second element. Yes, I want it. Right. So these two parties can be called as an offerer, and the other party who accept the proposal is called as offeree. Same goes to promiser and promisee. Okay, so that is actually an offer. Okay, so types of offer. So the offer can be only accepted by a person who been offered. You are offering to somebody, that party B, C cannot accept it on behalf of B. All right. So the second types of offer is very general offer. It can go to as a public, so it's not only for one person. So this is the difference of the offer. So if you look at the slides here, take your time to click the YouTube link for both study case on the case for the for related to the offer itself. So pause your presentation and go to the YouTube link to watch the presentations of the difference of the specific offer and general offer. Okay, next one. So in the elements of offer, okay, the offer must be firm and not vague. Okay, the offer can be accepted by a person who been offered just now, and it must be communicated completely, which is the communication to the offer must be complete when it comes to the knowledge of the person to whom it made. So when you are doing an offer, the acceptance for the party B must be communicated through and understandable. It's very simple on the elements of the offer. Okay. So this is just another case, right? Based on the offer related to the communications, right? So if you look at here that below is the communications through the telegraph between two parties A and B. So person party A say, can you sell to us bumper hall pen? This is a land here. So answer for the lowest cash price by telegraph. So this is asking for the other party to answer by the telegraph. All right. So the second party, okay, the second party, which is B, send back the response. The lowest price for bumper hall pen is £900. So the last the response from the party from first party, we agree to buy bamboo hall pen at £900 as requested by you. So in this particular communications, right, is there an offer or any contract as this? So is there an offer here? This is actually going to be learned from you guys now. So this is actually a prominent case between Harvey and Facey. So the result from the case on this United Kingdom Privy Council says that based on this particular communications, right? Uh, Basically, there is no offer being made because the second answer is the lowest price for bumper hall is £900. So there is no actually an offer being made from this party to the first party talking about want to sell. Okay, so you can just try to understand, Google up for this case to understand more. All right. Okay, next one. The termination of offer. So of course, offer can be terminated by acceptance. Both parties accept to terminate the offer. So for the next one is one party reject the offer, right? The third one is by revocations at any time before the acceptance. So before you accept, you can revoke it. So by lapse of reasonable time, so you're giving some timeline, there's no response, so the offer can be terminated. And also the last one is by death of the offerer and of the offeree. So any party, if there's a death, then the offer is can be terminated. All right. So after terminations, the offer is no longer valid offer and cannot be accepted. Okay, so for the particular offer, right, before you enter a contract, okay, before you propose, there is actually another term they call it invitation to trade. This is ITT. So what does it mean? This is the term means it refers to an invitation for a party to make an offer to start the contractual negotiations. So this is normally you can see very simple example at the shopping mall where it starts to put advertisements, right? Advertisements, and then you can see that based on the advertisement, it's actually to invite you to come to the shop and do the contracts over there. So this process is called invitation to trade, where it just make an offer to start the contractual negotiations. So same goes to this one. This is also another advertisement, right? You just look at the advertisement here. You want to go for the contract, then you go to the salesman and go and try to work out the contract to buy the car. Same goes to auction. Auction is actually showing what are the it's not yet a contract because it's actually try to advertise or try to tell you guys what you're going to sell, and then later the person who wants to bid, then you're going to make it going to the contract itself. So this is the terms of invitations to trade. Okay, after the offer, the second elements of the contracts, of course, is acceptance. It's actually the other persons to accept it. So when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So you have the offer, then you have the acceptance. That is the second elements of the contract. Okay, so of course the acceptance must be absolute and unqualified for virtue of section. Okay, so acceptance must be made within a reasonable period. So that's why just now when you look at the termination offer just now here, so if the offer is not being answered by a lapse of reasonable time, the offer can be terminated. So same goes to this one. So that is a case for height and range here. Okay, this is another thing related to the acceptance being not accepted because the other person is talking about counter offer. So counter offer is means that when you offer somebody, then these guys try to bargain, which is a counter offer, then the first contract is not going to be valid anymore. So have your time to click on the link here to find out the case of Hyde versus Ranch in 8040. Okay, once you complete that one, means you have to understand the issues on the counter offer here. So the next one is acceptance must be expressed in some usual and reasonable manner unless the proposer prescribe the manner in which it's to be accepted. Okay, so that is the offer and acceptance. Okay, let's move on. The communications of acceptance. Acceptance is only effective when it has been communicated. Okay, it can be made by word or mouth, letter, text, facsimile, or recorded messages. So in Malaysia, the Contract Act stipulates different times when the communication of acceptance is complete. Section 42A, to offerer when it is put in the cost of transition to him. Second B, to offeree when it comes to knowledge of the offerer. So in easy word, for the offerer, the first is actually is start to do the communications, right? So for the second, for the offeree, so this is just to make it easier. So the informations got or get by the offer itself. So you have to communicate. A must communicate to B. It's very simple like that. Okay, so the third element is intention to create legal relations. So in a contract, right, you must have the intention to create legal relation, because without this one, it's very hard for you to come up as that one is a contract, because by law or by the court, it must have these legal relations for it to be possible. All right. So both parties must intend that the agreement is to be binding on them. Okay, they must agree to bear the duties under the contract. So intentions is the most important element which will charge an agreement to contract. So all contract is an agreement, but not all contract. All agreement is contract. So that's why. So you must make sure that you must have the intention to create legalation. So this is basically like you have the paperwork, all that's one, and then you have to give the terms and regulations, all this thing, okay, as an offer. So it must sign by both parties. So this is actually a legal relations. Okay, so this is the case, prominent case also. All right, so whether these are husband and wife is actually have the intention to create legal relations. So this is the case where husband and wife, okay, being related to the when the wife is suing the husband itself. So if you want to know about this one, get some pause your time and then you just click to the link over here and then look at what happened to this case. All right. So in this case for Mr. Buffer, just for the conclusions, this is related to the domestic household, because this is related to the husband and wife. So it's very hard to prove that there is actually an intention to create legal relations. So that's why if you are doing a contract with other people, basically like banks, like when you go and purchase your food, right? All got receipts, all the contracts over there. So it's actually there's a legal relations, okay, for the contract being forcible. So in this case, just to conclude that Mr. Balfour and Mrs. Balfour is actually husband and wife. So in domestic household, it's very hard to prove that there is actually an intention to create legal relation, even though there's a promise in this case, right? So this is actually the third one. So this is the intention to create legal relations. Okay, let's move on. Next is a consideration. So consideration is actually what you want to consider inside your contract itself. Right. So the general rule in the contract is that an agreement without consideration is what, of course, you are not actually what you want to do in an agreement. So consideration is a promise, performance, or forbearance bargained by promiser in exchange for the promise. So it's just very simple. You want to purchase a car with this value, so you have these considerations to say that this is a car, you have to pay for that one. All right. So it refers to something of value exchanged between parties as a part of the contract. Consideration is what distinguishes a bargain or contract from gift. all contract is an agreement, but not all agreement is a contract. So again, this is another example here for the consideration. So failure of consideration. So let's look at this case. This person want to send a cakes for this lady, right? So the lady is talking about she wants up to 52 cakes on Friday, but when the delivery comes, only 50 cakes only, so they are short of 2 cakes. So the consideration is not correct, right? Because the offer or the acceptance is talking about 52 cakes. So when the delivery is only 50 cakes, so the second party have the rights to reject the offer because it does not fulfill up the considerations. Okay. So there are three types of considerations. Okay, so there is actually a past consideration. So there is executed consideration. So the third one is executive consideration. So the consideration is based on the time. So this past is related to the past. Executed, this is has been done. Executed means you have executed it. And the last one is executive consideration is about the future executions. So that is actually the types of considerations. Okay, the next elements, they call it capacity. Okay, for a contract to valid, it must have these elements too. So capacity is related to the whether the person who doing the offer and the offering must have this capacity to make sure the contract is valid. All right. So the parties entering into a contract should be competent to contract according to the law, which is a subject and of sound mind. Okay, so every person is competent to contract. So all of us are competent to contract. Who is of the age of majority according to the law to which he is subject, and who is a sound mind and not qualified for contracting by any law which is he is subject. Okay, so there are two things. One is age majority, and the second one is must be a sound mind. So he's not crazy or what. So these are two capacities normally that we are talking about. All right. So what is a capacity related to the age of majority, right? So age of majority for our case in Malaysia, according to the Age of Majority Act 1971, for every individual person, the age of majority is 18 years old. So we can do a contract when we are 18 years old. Okay, most of the thing. All right. Right. So the next one is son of mine. Okay, a person is said to be son of mine for the purpose of making a contract if, at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. So he must not crazy, he must be a sound mind, means that he can understand and make a judgment on the offer and acceptance and the whole overall contract. Okay, so let's look at the study case on every agreements made by a minor is not a contract. So a minor is basically a person which is below than 18 years old. So take some time to look at the two cases, Mohari Bibi versus Damados Ghost and Tan Hee Juan versus Tan Teh Byun Kit related to the issues of the minors. Okay, the next one. For the case of age of majority below 18 years old, there still has the exception. Okay, for the minor, there are three exceptions for the case. The first one, they call it marriage contract by minor. The second exception is any other act allowed under any law. And the third one, the contract for necessary. So this is the exception for the minor because, of course, they must have their own what you call that, they still need to have this one because even though there's an age of majority here, but these are the exceptions. Okay, so let's look at the first one, marriage contract by minor. So this is also another case for Rajeshwari Anno in Balakrishnan Ors. This is in India. So this is related to the marriage. Okay, so you can have your time to click on the link to understand the issues. So in conclusion, in this case, for the marriage contract by minor, it's still enforceable by law because it is a capacity exception for the minor. Okay. The second one, they call it an act allowed under any law. So these are the examples of the act which is not for the minor, which is allowable for the minor, right? So this is quite old already. This is actually in the Sharia Act today. Now you've been moved to 18 already. And then you have the Employment Act 1955. You are going to have 14 years old to work. Okay. Then you have the scholarship. All right. This is a scholarship. And then the third one is insurance. This is all another act which is allowed for the minors. So like you guys, right? Some of you maybe have the scholarships. So you have to sign the contract for the scholarship. So that is actually an exception for you guys to have the contract. Okay, the third one, for the exception, they call it for the contract for necessary. Of course, necessary for the kids. So these are the 5 things that the kids have for its necessity. So the first one, of course, clothes, then medical treatment, house, food, education. So these are related to the kids. So they must have it, right? Because of course they want to buy food, they still can buy it, make a contract on that one. So this is an exception. So there are 3 exceptions again. The first one, they call it marriage contract. The second one, they call it an act allowed any other law, under any law. And the third one, they call it for the contract for necessary. So these are the 3 exceptions for the minors. Okay, so that is actually for the first part of the contract. So we're going to learn for the rest of the contracts in the next lecture. Thank you very much for your time.